Please subscribe and click the bell button and like and comment. Criminal law definition of terms. 1. Criminal law is that branch or division of law which defines crimes, treats of their nature, and provides for their punishment. 2. Crime, defined as an act committed or omitted of violation of public law forbidding or commanding it. General characteristics of criminal law. General, in that criminal law is binding on all persons who live or sojourn in the Philippines territory. Territorial characteristics of criminal law. In that criminal law undertakes to punish crime committed within Philippines territory. For prospective, one of the characteristics of criminal law. In that a penal law cannot make an act punishable in a manner in which it was not punishable when committed. 6. French rule. Such crimes are not triable in courts of that country, unless their commission affects the peace and security of the territory, or the safety of the state is endangered. English rule. Such crimes are triable in that country, unless they merely affect things within the vessel, or they refer to the internal management thereof. Felonies. Felonies are acts or omissions punishable by Revised Penal Code. Act. Any body movement tending to produce some effect in the external world. Omission is meant in action the failure to perform a positive duty which one is bound to do. Mistakes of fact is a misapprehension of fact on the part of the person who caused injury to another. Malignancy, wrongful from their nature, thus so serious in their effects on society as to call for the almost unanimous condemnation of its member and defined and penalized by the Revised Penal Code. Mala prohibita, wrong merely because prohibited by statute and violations of mere rules of convenience designed to secure a more orderly regulations of the affair of society. The term mala prohibita refers generally to act made criminal by special laws. Intent. Intent is the purpose to use a particular means to effect such result. Motive is the moving power which impels one to action for a definite result. Consummated felony. A felony is consummative with all the elements necessary of its execution and a completed felony, when the offender performs all the acts of execution which would produce the felony as the consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. Attempted felony, when the offender commences the commission of the felony direct by overt acts and does not perform all the acts of execution which should produce the felony by the reason of some cause or incident other than his own spontaneous desistance. Overt acts is some physical activity or deed indicating the intention to commit a particular crime more than a mere planning or preparation, which if carried to its complete termination following its natural course, without being frustrated by external obstacles nor by the voluntary desistance of the perpetrator, will logically and necessarily ripen into a concrete offense, indeterminate offense. One where purpose of offender in the performing an act is not certain, its nature in relation to its objective is ambiguous. Conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. Proposal. There is a proposal when the person who has decided to commit a felony proposes its execution to some other person or persons. Imputability is the quality by which an act may be ascribed to person as its author or owner. It implies that the act committed has been freely and consciously done and may, therefore, be put down to as his very own. Responsibility is the obligation of suffering the consequences of crime. It is the obligation of taking the penal and civil consequences of the crime. Guilt is an element of responsibility, for a man cannot be made to answer for the consequences of a crime unless he is guilty. Grave felonies are those to which the law attaches the capital punishment or penalties which in any of their period are afflicted. Least grave felony are those which the law punishes who, with penalties which is in their maximum period are correctional. Light felonies are those infractions of law for the commission of which the penalty of arresto minor or a fine not exceeding 200 pesos is provided. Justifying circumstances are those where the persons is said to be in accordance with law, so that such person is deemed not to have transgressed the law and is free from the both criminal and civil liability. Exempting circumstances are those grounds for exemption from punishment because there is wanting in the agent of the crime any of the condition which makes the act voluntary or negligent. Mitigating circumstances, those which, if present in the commission of the crime, do not entirely free an actor from criminal liability, but only serve to reduce the penalty. Aggravating circumstances are those which, if attendant in the commission of the crime, serve to increase the penalty without, however, exceeding the maximum of penalty provided by law for the offense. Generic kind of the aggravating circumstances, those that can generally apply to all crimes. Specific, those that apply only to particular crime. Qualifying, those that change the nature of the crime. Inherent, those that must of necessity accompany the commission of the crime. Those four are kind of aggravating circumstances. Alternative circumstances, aggravating or mitigating according to the nature and effect of the crime and other conditions attending its commission. Instigation, public officer or private detective induces an innocent person to commit a crime and would arrest him upon or after the commission of the crime by him. Entrapment, a person has planned or is about to commit crime and ways and means are resorted to by a public officer to trap and catch the criminal, not a defense. Accidents, any happening beyond control of persons, consequences of which are not foreseeable. Treachery, when the offender commits any of the crime against the person, employing means, method, or forms in the execution thereof, which tend directly and especially to ensure its execution, without risk to himself arising from the defense which the offended party might make. Ignominy, moral suffering. Cruelty, deliberate intention to prolong physical suffering of the victim. Habitual delinquency, within 10 years from last release or last conviction of the crime of falsification, robbery, estafa, theft, serious or less serious physical injuries, the offender is found guilty of any of said crimes a third time or oftener. Recidivism, when the time of trial of one crime shall have been previously convicted by penal judgment of one another crime embraced in the same title of the revised penal code. Quasi-recidivism, commits a
Quasi-recidivism: commits a felony after having been convicted by final judgment before beginning to serve such or while serving the same, shall be punished by maximum period of penalty prescribed by law for new felony. Retardation or habituality: accused is on trial for an offense. He has previously served sentence for another offense to which attaches an equal or greater penalty, or for two and more crimes to which it attaches lighter penalty than that for the new offense, and that he is convicted of the new offense is an act or omission that is punishable by special law, such Republic Act, presidential decrees, executive orders, memorandum, circulars, ordinance, and rule and regulation. Penalty is the suffering that is inflicted by the state of the transgression of law. Complex crime: when the single act constitutes two or more grave or less grave felonies, or when an offense is a necessary means for committing the other. The penalty for most serious crime shall be imposed.
Thanks for watching. Bye bye.